leader with AgForce projects. I would like to welcome you to another webinar from AgForce projects, leader with AgForce projects. I would like to welcome you to another webinar from AgForce projects through our CSG and Mining Landholder Support project. Firstly, I'd like to begin by thanking you for giving me your time to listen this afternoon, and we will do our best to stay on time. We apologise for the late commencing of the presentation this afternoon. We had a few difficulties that are now hopefully being sorted. As you'll notice in the chat box located in the left hand of your screen, if you experience any technical difficulties either with the audio or with the presentation material coming through, please feel free to call Redback Conferencing on the 1-800 number provided and use the participant code that was emailed to you from AgForce Projects. The topic this afternoon will be focusing on the different legislative changes and amendments that have been introduced over the last 12 months, including groundwater management, the introduction of restricted lands, as well as the proposal for the introduction of a Land Access Ombudsman. This webinar this afternoon will briefly outline what these mean for landholders and what the next steps are for these amendments that are awaiting regulations or putting in place. At this point, I'd like to point out that before we start, the information contained in this webinar really does provide quite a high-level overview of these materials, simply because of the time we have today, but as well as also the number of details that are contained within these changes. So I would strongly encourage those with an interest or those that are actively managing activities on property or negotiating agreements to get in touch with myself so that we can dive into more detail about these changes and what they may mean for your negotiations or what they may mean for your activities moving forward. Just before we start, some housekeeping. This webinar is a listen-only mode, but at any point during the webinar, if you have any questions or comments or suggestions or feedback to make, please feel free to type these in the message box located at the bottom left-hand side of your screen. At any point in the webinar, please do feel free to ask any questions, or if we move over a point too quickly, please feel free to ask those questions. Following the webinar, we would ask you to, if you have any questions or comments or feedback, to please contact myself. My contact details will be recorded to everybody who has registered for the webinar this afternoon, and we will also be sending a recording of this webinar to all participants who have registered. If you're unable to listen to the entire webinar, like I said, the webinar will be recorded, so you will be able to receive a full copy of the recorded presentation if you feel the need to skip out. As I said, if you have any technical difficulties, please type them in the message box or please feel free to contact Redback Conferencing providing the 1-800 number that we provided you. With that, we'll start the webinar this afternoon. So what I would like to point out is that this webinar does again provide an overview of information and that the information contained in this webinar should not be used in lieu of legal or other professional advice, particularly because some of the amendments and regulatory changes that we will be talking about are still being finalised and developed. There's obviously a lot of detail that's important for landholders and those that are working with landholders. When everybody registered for the webinar this afternoon, we did ask you to provide some indication of what you would like to get out of the webinar this afternoon or what your main points were for attending. We've reviewed those questions and those comments, and I think that we've been able to answer all of those questions and comments throughout the materials that we have developed. However, if there are any additional questions, please do feel free to contact myself. And like I said, my contact details will be provided following the webinar this afternoon, as well as contact representatives of the Coal Seam Gas Compliance Unit within the Department of Natural Resources and Mines for further information. As we start this webinar, I'd like just to provide a few key points of what we will be addressing in some of the take-home messages. So what we'll be showing you and outlining is that there have been some amendments and changes to the groundwater management and make good laws and make good framework as it applies to both mining activities as well as coal seam gas. We'll also be presenting that there has been a review completed and released into the GasFields Commission, released late 2016, which has made a number of recommendations. Attached to some of those recommendations was the proposal to introduce a Land Access Ombudsman, and we'll be outlining the role of the Land Access Ombudsman as well as their responsibilities moving forward. One of the other key messages is that some of the amendments have now made it possible for landholders who are entitled to access professional hydrogeological or groundwater advice as part of your make good negotiations. We'll also be presenting the legislation that has outlined the introduction of what are called restricted lands for both coal seam gas and mining activities, as well as outlining some changes to the proposed land access framework, including dispute resolution. So these are the items that we hope to provide and take home from the webinar this afternoon. As a precursor to starting these changes, what we'd like to highlight is some of the development and activity that's been occurring across the CSG industry since the project started in 2011. And this slide gives you an overview of the number of wells and the level of activity that's been increasing since the project started in 2011. Right through to the point as of February this year, you can see that there's approximately just under 10,000 wells right across Queensland that are at various stages, whether they're appraisal, exploration or production wells. One of the significant figures to take home from this point is the number of production wells being at about 6,800 wells, up from just under 2,000 wells in 2011. So what this signifies is a significant escalation in activities during this period, but also shows that in comparison to the expected number of wells across the lifespan of the industry, being between 18,000 to 40,000, there still is significant development yet to occur in this industry, and the reason of why we're encouraging landholders to remain informed about the development of the industry, changes in legislation, and also landholder rights. The map on your screen shows the 3 sedimentary basins across Queensland that the activity is occurring. The Surat Basin in blue, the Bowen Basin in green, and the Galilee Basin in red. The individual dots on the map represent individual coal seam gas wells that have been drilled since, in black, that are wells that existed as of 2011, and the red dots symbolise wells that have been drilled since 2011. And obviously we can see across the Surat Basin region there's been a significant escalation in the number of wells that have been drilled across this period, and shows the footprint of the industry that's expanding. Like we've said earlier, some of the information contained in the industry shows the development of wells, and since 2011 we've obviously seen a rapid escalation in the number of gas wells that have been drilled. Contained in the 2016 Surat Basin Underground Water Impact Report, or the groundwater model, this model based the long-term predictions of the industry in terms of groundwater impacts on a production of up to 18,000 wells. So when we look at where we are now in terms of 6,000 odd production wells, like we're saying, there's still significant development that is yet to occur, symbolising the need for landholders to remain informed, but also the continual requirements for legislation to be adapted and amended as the development of the industry continues. Contained within the 2016 report, which has been seen in previous AgForce projects webinars, was the revision or the changes of the development schedule of the industry. So these 2 slides, the picture on the left-hand side shows the information that was contained in the 2012 Surat Basin groundwater model, which showed the number of the tenure area or the production area that was planned for CSG production. So you can see in 2012, the blue squares represent current or coal seam gas tenures that were currently in production as of 2012, and the yellow squares represented areas where coal seam gas production was planned across the lifespan of the industry. In the 2015-2016 model on the right-hand side, you can see that there's been a reduction in the level of planned tenures, symbolised by yellow, but also an escalation in the number of blue tenures, which were tenures that were currently in production. And we can see from the slide that the number of production tenures that are planned to be brought in across the lifespan of the industry is going to continue for some time now onwards. So what we would be advising landholders for these key points is that the industry is continuing to expand, increasing both the number of individual wells, but also the supporting infrastructure. And with approximately 6,800 production wells drilled so far, and the estimates being up to 18,000 production wells, there's still development that is likely to occur. The other key point for landholders is that the industry is yet to reach what is called peak CSG water production. So this is water that is produced in the process of extracting gas. And as you can see, in 2015, approximately 65,000 megalitres were extracted by the industry as associated water, and that peak production of coal seam gas water is expected to reach up to 110,000 megalitres. So representing, again, in terms of the peak number of wells, but also peak water drawdown is yet to occur. And this is why AgForce is continually encouraging landholders and those working with landholders to remain aware and informed of changes to legislation as well as policy and industry developments. The Coal Seam Gas project that's running this presentation has funding until 30 June this year, and we're encouraging landholders to use this service while it's still available, and also agribusiness professionals and professionals dealing with landholders to continue to work with the project to make sure that you're up to date with the most current information. So moving into the webinar presentation this afternoon, we want to talk about some of the legislative changes that have occurred over the last 12 months. In terms of groundwater laws, we've broken this up into a few different sections. As you can see on your screen, there's been a number of amendments that have been made to the Water Act, which is the overarching piece of water regulation in Queensland. There's been amendments made to the Water Reform and Other Legislation Amendment Act from 2014. And there's also been the introduction of the Environmental Protection, Underground Water Management and Other Legislation Amendment in 2016. And some of these amendments some of these legislation pieces amend existing legislation, and some of them are new legislation creating new requirements for both coal seam gas and mining companies. So as probably many landholders were not aware that some of these amendments commenced in late December 2016. One of the key parts of the Reroller Act was to expand the underground water management framework to the mining sector. So this was designed to align both the coal seam gas groundwater management framework with the mining industry sector, ensuring that both coal seam gas and the mining sector were under the same framework. So what this means for landholders is that if you believe that your bore is experiencing an impact as a result of a mining company's activities or their right to take groundwater as part of their activities, then the landholder will now have a statutory right to a make good agreement. So this has been quite a significant development for landholders dealing with coal mining and mineral exploration companies. So what we've provided here is a little comparison of the possible scenarios. So on the first box you can see that if a groundwater model, so as required with coal seam gas companies and future mining companies, if a new project is to be approved, they're required to develop a groundwater model. And that groundwater model is used to identify the potential impacts to landholder private landholder bores in both a short-term period and a long-term period. If the model identifies that a landholder's bore is likely to be impacted as a result of their activities, then a landholder is entitled to a make good agreement. In the other option, if a landholder or another person working with a landholder detects that there is either a water supply loss or an impairment to a landholder's bore, and that is found to be or is likely to be the result of a resource activity, either mining or CSG, then a landholder is entitled to that make good agreement. So what you can see then is the next process is that as a result of that legislative obligation to develop a make good agreement, a landholder and a resource company will then develop what are called make good measures, which are to develop a suitable supply or alternative arrangements such as developing a new bore, providing surface water or working out financial compensation. The key point here is that landholders should be aware that if an impact is not predicted to your bore through a groundwater modelling process, so this is a predictive process, but your bore is experiencing an impact once those activities start, regardless if they're coal seam gas or mining activity under these new amendments, then you're entitled to a make good agreement if that project is captured by these new changes. So what this process provides and what this framework ensures is a more preventative process for managing groundwater impacts rather than being a reactive process. This is quite an important change for landholders to be aware of that are dealing with mining companies. For coal seam gas companies, there's been no change in this process. Coal seam gas companies were always required to develop these models and proactively enter into make good agreements, but this legislation brings the mining industry under the same framework as the coal seam gas industry. Some of the other significant and important changes that have been attached to some of this legislation and now provides the right for a landowner or a bore owner to be reimbursed for the necessary and reasonable hydrogeological or groundwater advice or cost associated with developing a make good agreement. So this has been a critical and quite important requirement for landholders that have been negotiating through the Make Good framework to allow landholders to be able to engage that professional advice to advise them about the adequacy of the assessment or the adequacy of the proposed Make Good measures to make sure that they're going to provide a effective and suitable Make Good agreement for the landholder's water needs and making sure that's based on proper and independent groundwater science. Attached to these amendments were also the requirement to develop a dispute resolution process for Make Good agreements, and that as attached to this process, the costs of facilitating what's called an alternative dispute resolution, or ADR, in this process will be the responsibility of the tenure holder. So what these changes provide is a baseline for landholders to be able to engage professional groundwater advice, but also will put in place a clear dispute resolution process to assist in that Make Good negotiations, which is similar to what exists in the Land Access framework in a graduated dispute resolution process. One of the other significant amendments that has also been attached to this legislation and came from a lot of landholder feedback was the ability for Make Good legislation to encompass and cover bores that experience an impact as a result of free gas being generated by the resource company. So this is generally what's been termed gassy bores. So pre-existing to this, if a bore owner or a bore experienced a drop in either their pressure or their standing water level as a result of the coal seam gas activity, and that resulted in a supply loss or an impairment, then landholders were entitled to a Make Good agreement for that impact. However, what was missing from that framework was an emerging issue in free gas migrating into landholder bores from a reduction in pressure or standing water level in the coal seam and the impact that was having on landholder bores. So the ability for landholder rights having now been expanded to include the generation of free gas, and that gas creating a supply issue, is an important step in the Make Good process for landholders. A 5-day cooling off period has also been, will also be integrated into the Make Good framework, which will allow landholders a 5-day period to terminate an agreement without penalty if they choose to revise or new information comes through to interface. And some of the amendments have also sought to clarify where Make Good obligations apply. And this is important, looking at when Make Good obligations will apply, where there is a likelihood of impact rather than a specific certainty that the resource activities caused, or what they called materially contributed to a water supply loss or impairment issue. So what this is an important step towards is taking away the obligations purely on the landholder to prove definitively that it was the resource company's activities, and being a step towards making sure that where an impact is likely to be caused or materially contributed by a resource company's underground water exercise rights, then a Make Good issue or Make Good agreement will apply to those conditions. While we're talking about Make Good, it's probably important for some people to understand about what actually Make Good agreements are. And for the purpose of today's webinar, this will only be a brief introduction as we spend a whole day talking about Make Good agreements. But as many who registered for the webinar had an interest in this area. So a Make Good agreement is an agreement that is separate to a conduct and compensation agreement, or a CCA. And what it refers to is a resource company's obligation to make good where there is an impact, or where there is predicted to be an impact, or impaired bore capacity or loss of supply due to that coal seam gas or mining activity. So Make Good agreements, like we've said, cover both actual impacts, where they actually are experiencing an impact, as well as predicted impacts. And they're two key points for everybody to take home. When we look at what Make Good agreements may include, these are termed Make Good measures. Now these may include and are up for negotiation between the landholder and the resource company. These may be deepening the bore to either a deeper area within the same aquifer, or drilling a new bore into a different aquifer, providing financial compensation to the landholder, lowering the pump or increasing the pump capacity and size, or providing an arrangement to access surface water. So the key point to understand is that this is a negotiation between you as the landholder and the resource company, and ensuring that either a satisfactory outcome in terms of compensation or an alternative supply is reached to provide you with the same ability to access water as you would have pre-resource industry impacts. Some of the considerations that we're advising landholders to take into account, for those of you that have been approached to either negotiate or make good agreement, or may be approached in the future to access or to develop a make good agreement, are encouraged to seek both legal and now exercise your rights to access technical groundwater advice before signing any agreement. AgForce projects through the CSG Mining project can provide advice and support to landholders through this process, as well as the groundwater investigation team within the coal seam gas compliance unit. And we'll be providing the contact details for both the projects team, but also for the coal seam gas compliance unit, and ensuring that landholders really do contact the compliance unit with any questions or concerns, and particularly exercise their rights during the make good process. To support landholders through this process, we've developed a bore assessment guideline and checklist, as well as additional supporting materials to help landholders understand and navigate their way through the make good framework, and to understand very clearly what your rights are, what your obligations are, and what the processes are. And these materials will be updated to reflect these changes. AgForce projects, we can also hold what we call groundwater field days in your town to explain this process and to explain your rights. So if anybody is interested in having AgForce projects come out to your town or to your region to hold a regional workshop to actually go through the groundwater process, to look at the process of developing a model, and to actually delve into a lot more detail into your rights through this process, we're certainly able to do that for free, and we encourage you to contact our projects team for information. On your screen, you'll see some contact details for both the compliance unit as well as the AgForce projects team. We've also provided some links to some websites through the Department of Environment and Heritage Protection that will outline both the changes to the groundwater management framework that we've spoken about. Will also allow you to access and review the model, the groundwater model that was released in 2016, that makes predictions about the short-term and long-term impact of the CSG industry, and also includes a function that allows landholders to search the model by registered bore to see if your bore has been identified as potentially being impacted, and what that potential impact may also be. We've also provided a link to the Queensland Government Coal Seam Gas Globe through the Queensland Globe, which will allow you to view the groundwater impact areas, looking at the map from a spatial aspect, and will allow you to individually click on different bores that have been identified as being impacted, and also see what that potential impact has been. So these are some quite useful and important resources to be made aware of. The next topic to talk about in this afternoon's webinar is looking at the 2016 GasFields Commission review, looking at what some of those review findings were, looking at the new lineup and new structure of the GasFields Commission, and also looking at some of the other recommendations that were attached to that review, particularly looking at the land access framework and also the development of a land access ombudsman in this process. So throughout 2016, there was a detailed review of the GasFields Commission that looked at its functions, its work, and also was designed to provide the Queensland Government and the Minister with recommendations about how to improve the functionality of the Commission, and also to make some other recommendations to the process. So the review sets out 18 wide-ranging recommendations, and some of those that are specific to the GasFields Commission were to clarify both the roles and functions of the Commission, but also the responsibilities of the GasFields Commission. So what is designed of this process is that communities, those working with landholders and government, and everybody involved in the industry will have a much clearer understanding of what the GasFields Commission, their responsibilities are and their requirements moving forward. One of the recommendations was to develop a renewed focus for the Commission on the extension and communication activities to improve the information that's available for both landholders and communities, as well as provide the ability for the Commission to provide advice to landholders, companies and government on dispute resolution processes. The Commission will now consist of a full-time chair and 3 part-time commissioners. To introduce the new Commission leadership, Ruth Wade will take over as Chair of the Commission. Ruth was formerly the CEO of the Queensland Farmers Federation, or QFF, and has an extensive background in agriculture and agri-politics. So Ruth will take over from John Cotter as the Chairman of the GasFields Commission. Fleur Anderson, who's a landholder from Theodore, as well as a non-executive director on the board of Cotton Australia, will also take on the role as a part-time commissioner with the GasFields Commission. Ian Haylor, who's been a GasFields Commissioner since the beginning of the Commission in 2013, will continue in his position and being a Darling Downs irrigator. And Rick Wilkinson, who is also a Commissioner from the formation of the Commission, will continue in his position, and as well as being the Chief Technical Officer for the peak industry body for the gas industry through APIA. So at the moment, what we're encouraging landholders to do is to take the opportunity to contact the Commission, to provide your experiences on both your interactions with the Commission, as well as your experiences with coal seam gas and the industry, to allow you to provide your experiences and use your insights to assist the Commission and assist the government to continue to improve this important service, and continue to improve the information that's made available to landholders, and really outline to the Commission, to us and to the government as landholders what really is the information and support services that you need to effectively navigate and manage the CSG negotiation process, and what can we do using the lessons learnt over the last 6 to 8 years about the industry to make sure we continue to improve things for everybody. For those of you who are interested, you can visit the Department of State Development website to review the report that was released by Bob Scott, the recommendations of those reports that were proposed to government, as well as the responses that government has outlined in response to those recommendations. And the link has been provided in the webinar and will be emailed to everybody this afternoon. Some of the other recommendations that were broader recommendations for the GasFields Commission was to look at amending CSG and water legislation to provide for a distinct arbitration process or dispute resolution process for Make Good, and also look at making improvements to this process for the land access framework. There's also a recommendation to look at amending legislation to ensure that the tenure holder, so the resource company, would be required to pay those costs associated with dispute resolution. And also another recommendation that proposed the establishment of a Land Access Ombudsman, which is and will be separate to the GasFields Commission, to manage and handle disputes between landholders and resource companies. So the Land Access Ombudsman, so one of the, like I said, recommendation was that a Land Access Ombudsman be developed and implemented. The idea of the Land Access Ombudsman would be they would play a central role in investigating the conduct in all parties of disputes, that they will also have the ability to provide advice, offer opinions, and also provide options to landholders and companies during these disputes, and that they'll also have the ability to make recommendations to both the regulator and to the courts during this process. One of the key points to be aware of with the proposal of a Land Access Ombudsman is that their role will only be involved in disputes post-CCA. So they will not be involved in disputes that are in the process of negotiating a conduct and compensation agreement. So this is your land access agreement prior to activity started. Their role will be in managing disputes after the agreement has been signed and activities commence, regarding dispute resolution about the agreement contents after it's been finalised, or conduct of activities or other issues that arise with landholders. So it's important to understand that the proposed amendment will be that the Ombudsman will work after agreement has been finalised in dispute resolution, and clearly that the Ombudsman will be separate to the GasFields Commission. So at this point in the process and development of the Land Access Ombudsman, we really want to hear from landholders, and we really want to hear from those working with landholders. So at the process now, AgForce is continuing to work with the government, Queensland government, and all stakeholders are involved in developing the functions and also the overarching development of the Land Access Ombudsman and this dispute resolution process. And we're really encouraging landholders to contact the CSG Mining team to provide information about your experiences with CCA disputes or land access disputes. What are some of the major issues that you've been experiencing in your role as a landholder, and what are some of the ways that you would see as being an effective dispute resolution process, and really asking landholders to guide us in the discussions that we're having with the department about how best to maximise the effectiveness of this new proposed body, and then really stressing to everybody at this point the recommendations are still being worked through and the proposed amendments are still being developed. So we're at a point where we can have a say in this process. Moving on to some of the updates to the land access framework. In September last year, we had the commencement of some amendments to the Mineral and Energy Common Provisions Act, which originally was introduced in 2014 and has had some recent amendments across 2015 and 2016. Some of those key points were the development of a restricted lands framework for both coal seam gas and mining, the development of what are called opt-out agreements for landholders and resource companies, as well as broadening or re-establishing of the ability for landholders and communities to object to mining companies. At this point, the transitional amendments for the components of this legislation and the supporting regulations behind this legislation are currently being developed. So what we'll be presenting this afternoon is information that sits as taken from the Act and as will be the steps moving forward, and obviously the supporting regulations and the supporting framework to these amendments will have quite an impact in this process and are still being developed at this process, which AgForce is working with the department and all stakeholders about. So these amendments commenced on the 27th of September last year. As I indicated, it created a consistent restricted land framework for all resource authority types. So where there previously was a restricted lands framework under the Governing Act for mining companies under the Mineral Resources Act, there's now been the ability to expand that framework to apply to both petroleum companies and mining companies and other resource authority types. What it also does is it provides the ability for landholders and resource companies to enter into what's called an opt-out agreement instead of actually negotiating a conduct and compensation agreement. And we'll be speaking about that in a little bit more detail. It also reinstated community objection rights to mining projects, being instead of being restricted to only affected or nearby landholders, a restoration of those rights to all landholders and community members. It will also require that conduct and compensation agreements, so your land access agreement, as well as any opt-out agreements, will also be recorded on title, which is a process similar to an easement, being noted on property title. It's critical that you understand that the conditions, the details and the specifics of that CCA will not be noted on title, will not be made public. That information will still be between you and the resource company, but simply that there will be an indication that there is a conduct and compensation agreement over that property for those activities, and that's the only level of information that will be contained. So when we look at the restricted lands process, what we have now is the development, like I said, of a constricted and consistent framework across both resource types. So the first point is a development of a 50-metre buffer, which will exist around key infrastructure such as principal stockyards, bores and artesian wells, dams and artificial water storages that are connected to a water supply. It will also establish a 200-metre buffer zone that are around permanent buildings such as places of residence. And it's critical to understand that these restricted areas only set a minimum distance and not a maximum distance. And that accompanying to these processes, resource companies are still required to comply with conditions of their environmental authority, which in essence is a rule book for resource activities, which will stipulate conditions about the amount of light, dust or noise or other provisions within their environmental authority that they must comply with, and also being aware that the company also must comply with conditions that you negotiate. So some landholders have indicated that this change creates an alarming reduction for landholders, and the key point really is to understand is that these provide for a minimum distance, not a maximum distance. So similar to the land access framework, where there's a minimum time frame for negotiating and a minimum time frame for dispute resolution, these buffer zones create a minimum distance that companies must comply with. And at the end of the day, it's still up to you and the resource company to negotiate the final location and position of those activities, and being able to make sure that you exercise your rights to put back to the resource company to get them to explain and outline how they can comply with the conditions of their environmental authority within a prescribed distance of a sensitive area. So what we've provided you is a bit of an example showing these restricted areas in a land access negotiation process. So using a mapping tool, which we've often explained to landholders is a very valuable tool to be used in both developing a conduct and compensation agreement, but also being a really important tool to be used in determining both compensation from the potential impacts of the proposed CSG or mining activities, and also being able to use that map or that property plan as a comprehensive tool to be able to identify what those potential impacts are likely to be, or identify areas of conflict, and be able to use that map to be able to determine better locations to minimise that impact, and also use it as a tool to determine compensation. So in this example, what we've provided you with is a series of interconnecting roads proposed by the resource company, as well as a number of individual CSG wells that have been earmarked for development, and showing their location and proximity to both bores and the 50-metre buffer zone around the bores, and also a house showing a 200-metre buffer zone around that house. And these are tools that you can develop using Phoenix Mapping, which is a program that we use. As you can see in this example, it's important that landholders really understand that the activity is only permitted within these restricted zones by consent from the landholder, so by landholder agreement. So the activities can only come within those prescribed distances if the landholder agrees to that process. And this is where being able to have a digital computer mapping tool allows you to create these buffers around sensitive areas, and you can create your own buffers. So being able to look at experiences that you've had on your property, or talking to other people who have been through the process, or using the information contained within our project, we can give you some guidance, and those other people that have been through the process can give you some guidance about, well, what are some of the impacts that are potentially likely from gas activities, or what are some of the impacts that come from developing a road or drilling a well, and from their experience, what are some of the buffer zones that you would put around sensitive areas such as bores or dams, troughs and yards, and obviously houses as well. And obviously also using your legal expertise, using the solicitors that you have engaged in this process to provide you with some information to guide you through these steps, to look at identifying how best to manage this process, and really understanding that, like I said, these distances are only minimum distances, and having a property mapping tool is a really valuable process to be able to assist you in these negotiations. So like I've said, it's important that you understand that the introduction of these restricted lands means that companies are required to comply with these minimum distances, but they're also required to gain your consent as a landholder for activities within those prescribed distances of those restricted areas. And like we've mentioned, that companies are still required to comply with the conditions of their environmental authority regarding light, dust or noise pollutions, and that this still is a negotiation between you and the resource company, and using the expertise advice that you gather through the negotiation process to come up with a better location or to come up with a compensation amount that adequately reflects their potential impact. Like we've said, AgForce projects can help you through this negotiation process, and we can help you to develop these maps, and we can help you to develop property plans that will assist you through the negotiation process. And for anybody located in or around Roma, Miles or Dalby, in the last week of February this year, we'll be holding property mapping workshops in Roma, Miles and Dalby, which will be sitting down with landholders and sitting down as a group to actually show you how to use a property mapping program, and also take you through the steps of being able to develop your own property map and use that property map as a tool in negotiations with resource companies. And we'll be able to provide you with real examples of actually how to use that program as a tool to really effectively contribute to your negotiations. And details for those workshops are available on the AgForce Projects website, which will be available. The other key point for landholders to be aware of, and anybody that is approached or considering about negotiating an opt-out agreement, needs to understand that opt-out agreements are not mandatory. So there's no requirement for you to sign an opt-out agreement, which effectively means that you're agreeing to opt out of the land access framework, opt out of the requirement to develop a conduct and compensation agreement outlining the conduct of activities, the location of activities, as well as compensation that may be due for those activities, and permit access to that resource company, access to your property to be able to carry out those activities without that conduct and compensation agreement in place. So we're strongly advising any landholders who are approached to develop opt-out agreement or are considering opt-out agreement or would like to know more about what that process means, to contact the AgForce Projects CSG and Mining team, and also contact the Coal Seam Gas Compliance Unit to ensure that you really clearly understand your rights through this process. Attached with these opt-out agreements, there are some mandatory provisions, such as it must be accompanied by a special information form which will outline your rights, in trying to ensure that you understand that the process you're entering into, what it means in essence, that this is in a prescribed form that will be developed, and that also this process is subject to a 10-day cooling off period after an opt-out agreement is entered into between you and the resource company. And it's also important that you understand that this opt-out agreement does not negate the obligation that a resource company has to compensate you for any compensation that you're eligible for. But again, our strongest advice is for any landholders who are considering this process is to please contact AgForce for information on this process, or if you're dealing with landholders and you want to know more about the opt-out process, that we strongly encourage you to contact us for more information and to contact the Coal Seam Gas Compliance Unit. The intent of these agreements is that they will be for smaller scale activities, so they wouldn't be used by larger activities for developing wells or large infrastructure and property. But these these agreements are purely for small scale activities, and in many instances where there's an existing relationship and understanding between the landholder and the resource company. But aside from that, we're again encouraging anybody to ensure that you are aware of that process and contact the AgForce or the compliance unit for more information. So before we start to close down the webinar, again, if there are any questions on this process, or if you'd like to have any points clarified, please feel free to write them in the chat box, and we'll answer them before we close. Or again, the information, you can contact myself after the webinar to discuss this more. So in summary, and in closing this afternoon, what we've presented is that there are some amendments to the groundwater management framework, and that there's been amendments to the Make Good laws covering both coal seam gas and mining activities, and essentially bringing new mining projects and transitional projects under the same Make Good framework. And In this space, there will be some developing provisions around which projects will be captured under the new framework and which will continue under the existing framework, and the process to incorporate those across. And these are currently being developed. So at this point, it's still being worked through. It's important that landholders understand that you're entitled to access professional groundwater advice or professional hydrogeological advice in make good negotiations with the CSG or resource company, and that we encourage you to use that process and use that ability to get that groundwater advice and to use services such as the groundwater investigation team within the coal seam gas compliance unit and follow the advice of your solicitor during this process. We've also outlined that the review into the GasFields Commission was released late last year, and that has resulted in a new lineup for the Commission, a new chair in Ruth Wade, some new commissioners, and also a new focus for the Commission on looking at engagement, the development of information, and working with researchers to develop the best and most efficient options for information dissemination, engaging with communities in the industry, and providing transparent and factual information to everybody involved. Part of that review was also the proposed introduction of a Land Access Ombudsman, which is designed to hear disputes post-agreement, so after an agreement has been finalised and signed, that it's proposed that the Land Access Ombudsman will play a role in airing disputes and investigating conduct between landholders and companies investigating activities on property. And then it's important to understand that the Land Access Ombudsman is separate from the GasFields Commission, so the two will be very separate processes and functions. We've also outlined the development of a restricted lands framework for both coal seam gas and mining activities, and outlined the minimum distances or the prescribed distances from these areas that companies are required to comply with, and obviously very clearly understanding that as a landholder, these are minimum distances, not maximum distances, and that you're strongly encouraged to consider the short and long-term impact of proposed activities and infrastructure around areas on the property, and being able to quite clearly identify what are the potential impacts and what is the potential cost, and develop in your agreement the best way to mitigate or avoid those processes, or to adequately make sure that compensation reflects that process. We've also outlined that there are some proposed amendments to the land access framework, including dispute resolution. There are some developments that are being made at the moment looking at the negotiation timeframes and a supporting arbitration process to the land access framework. And some of these changes were in response to the GasFields Commission review and proposed recommendations about land access. And these amendments, these proposals at the moment are still being worked through, and AgForce Projects is involved in this process to develop refinements to the land access framework and process. And again, we strongly encourage landholders to contact us to share your experiences, to provide some information about what you've seen that has worked correctly and what's been incorrectly, and areas that can be improved. And we strongly encourage you to do that at the moment while we have an ability to really make some differences. So if there are any questions before we close the webinar this afternoon, please feel free to throw them in the chat box in the left-hand side of your screen, or please feel free to contact myself after the webinar. Whilst we're waiting for any questions, I'd just like to thank everybody for attending the webinar this afternoon. We had a fantastic high level of interest, over 140 people registered to attend this webinar, so it's great to see that the level of interest is continuing. We'd like to thank you for your time to listen and attend this webinar. Like we said at the start of this webinar, this really does provide quite a short introduction and overview of the proposed changes, and it's really important for many of you that are either involved in this process or involved with working with landholders to understand that this should be the first step in the process. There's a lot more information and detail behind these proposed changes and these legislative amendments that will take me a lot more detail to go through with you, and I strongly do encourage you to contact me, and encourage other landholders that are dealing with the process to contact myself or to contact the Coal Seam Gas Compliance Unit, and as well as the GasFields Commission, for more information about these processes. And like we've said, the projects team are able to assist you with any process or any step throughout the whole process. I'd just like to remind everybody, for those of you that missed it, that the recording of this webinar, so this webinar is being recorded. So everything that was spoken about this afternoon will be emailed to everybody who has registered and attended. So you'll receive a recording of the webinar outlining all this information and also some supporting information. So if you've missed anything or glossed over anything, you will receive a recording of the webinar with all of this information to review at your own leisure. When we close this webinar in a moment, you'll be automatically prompted to complete a survey, which is a really important tool that provides us with a bit of information about how we can improve the future delivery of these services, or how we can improve the information that's delivered to landholders, or if you have a specific request for either a negotiation workshop or a groundwater workshop in your region, we'll be able to provide you with that information as well. So please do take a moment to complete the survey. One of the questions I was asked is that in addition to groundwater advice, are landholders able to engage legal services or engage legal advice as part of the negotiation process? And the answer is yes. So as part of a negotiation, as part of a land access negotiation to develop a conduct and compensation agreement, you're entitled to be reimbursed for your necessary and reasonable legal, accounting and valuation costs as part of that process. So we strongly encourage landholders to engage those professional services to advise you through the negotiation process, including legal, accounting and valuation advice. And as outlined in today's webinar, this process will be amended to ensure that in make good negotiations, so where your bore has been either identified as being impacted or likely to be potentially impacted, that you're able to exercise impacted or likely to be potentially impacted, that you're able to exercise your right to gain groundwater information advice. So the idea is that through a make good negotiation, you'll have the ability for both legal, accounting and valuation and groundwater advice, and that through a land access negotiation, you will continue to have the ability to gain advice and have necessary and reasonable costs covered for legal, accounting and valuation advice. I'm conscious of everybody's time, that we're bang on time, and again apologies for the late running of the late start this afternoon. But I'd like to thank again everybody for listening to the webinar this afternoon, and please thank you for taking the time. Again, if there are any questions or comments after this webinar, if you'd like to contact myself or the Coal Seam Gas Compliance Unit, we've made those contact details available to you on the screen, and also will be emailed to you after this webinar as well. So thank you very much, and that closes the webinar this afternoon.